Really, I feel honored to be here tonight for this first Bird Flanagan Scholarship Banquet. My father, as Brother Northcutt said, Cleo Bird, was the last principal of the Pleasant Hill School. And he taught the 5th through the 8th grade because at that time, principals taught. Little Joyce Flanagan was the other teacher, and she taught the 1st through the 4th grade. Now, for my dad, most of his people are in Houston right now, but I do have one of his nieces here, Audrey Allen. A lot of y'all didn't know that, did you? And my daughter, baby girl, Zayla. And for Miss Flanagan, her family's scattered all around the states, but her sister is here, Sister Eva Goldston, who now lives back in the community. Amen. It gives me great pleasure to introduce the speaker for tonight. Now, I did not go to Pleasant Hill School, but this young lady, who is also my cousin, did go to this school. She is the 10th child born to the late Doss and Belzora Warren Pruitt. She was married to the late Frank Haynes and is the mother of 2 children. And I forgot to ask her how many grandchildren she had, but most of us are familiar with the one that's bike riding all the time.
She said 2.
And I think Sister Flo calls him Baby Shark.
Yeah, Baby Shark.
She has 2 children, Johnny Pruitt and Shanetta Drake. She attended airline school and Harbor College in Los Angeles, California. And some of her jobs have included Southwestern Bell Telephone Company, the accounting department in El Segundo, California. She was interim director and accounting administrator at the Oregon School of Arts and Crafts in Portland, Oregon. She's an administrative assistant and accountant at Arclitex Color Lab in Longview, Texas. Marketing and operations manager of NapMats until her retirement in 2020 in Austin, which is Pflugerville, Texas, where she has a beautiful home there, and now she's getting ready to move here, has moved here. She is a graduate of Linden Kildare High School, and she was a graduate of the last 8th grade class of that little 2-room Rosenwald school that you see up on the hill there, Pleasant Hill, as you came in. So I would like to present to you our speaker for tonight, the very well-educated and talented young lady, Mrs. Donetta Princetta Sharon LaRue Pruitt Haynes.
Hello. After that introduction with my name, I think it kind of stands that I will have to explain that to you. Those of you who don't know, my mother and father had 10 children. And when I went away to college the first time, I had to write an essay. And I said, I think I'll do an essay on the woman who did not know how to say no. Obviously, she did not know how to say no. But then when she had me, she was visiting a sick individual in the hospital in Texarkana and went into labor and had me. Well, before she went into the hospital, somebody asked her if it was a girl, could they name her Donetta? She said yes. Then when she had me, the nurse who was in attendance said, could you name that baby after me? My name is Princetta. She said, yes. Then the doctor who delivered me said, I would certainly love to name her after my wife. My wife's name is Sharon LaRue. Could you name it? Yes. So when it was all over and done with, I was Donetta Princetta Sharon LaRue Pruitt. My name was so long that my mother taught it to me in a song. My name is Donetta Princetta Sharon LaRue Pruitt. Don't do that to your children. I've been asked to speak to you today about the separate but equal law of the land. When I was approached by this scholarship committee and asked to speak to you on this concept of separate but equal, I thought, easy topic, since I lived it. But once I started to research this law, it became painfully clear that I knew almost nothing about it. And I'm reading a long ways from my paper. African Americans had to pay state and local taxes that were used for the benefits of white schools only. Even though the 13th Amendment abolished slavery and the 14th Amendment gave equal protection to all under the law, African Americans turned to the courts to help protect their constitutional rights. But the courts challenged earlier civil rights legislation and handed down a series of decisions that permitted states to segregate people of color. In the pivotal case of Plessy versus Ferguson in 1896, the U.S. Supreme Court ruled that racially separate facilities, if they were equal, did not violate the Constitution. Segregation, the court said, was not discrimination. If you remember the items that I passed around to you tonight, they were to show you that everything that looks the same, that you think is the same, if you examine it closely, you may find out it is definitely not the same. Separate but equal was a legal doctrine in the United States constitutional law, according to which racial segregation did not necessarily violate the 14th Amendment to the United States Constitution, which is nominally guaranteed equal protection under the law to all people. Under that doctrine, as long as the facilities provided to each race the same facilities that were equal, the state and local government could require these services, the facilities, to be public accommodations, housing, medical care, education, employment, and transportation, to be segregated by race, which was already the case throughout the states that were formerly the Confederacy. The phrase was derived from a Louisiana law of 1890, although the law actually used the phrase equal but separate. This doctrine was confirmed in the Plessy versus Ferguson Supreme Court decision in 1896, which was allowed states to sponsor segregation. Though segregation laws existed before this case, this decision embodied and emboldened segregation of states during the Jim Crow era, which had commenced in 1876, and supported the Black Code, which restricted the civil rights and civil liberties of African Americans during the Reconstruction period. In practice, facilities provided to African Americans were rarely equal and usually were not even close to equal, or did not exist at all. Although in 1954, Brown versus the Board of Education overturned the doctrine of separate but equal in institutions of public education, it would be almost 10 years more before the Civil Rights Act of 1964 would prohibit racial discrimination in facilities that were deemed public accommodations, transportation, and hotels. Consider, I was born in 1951. We did not have these rights until I was almost ready to graduate from high school. In 1896, the numbers of the United States Supreme Court under Justice Melvin Fuller established a separate but equal rule. This ruling was promoted when in 1890, a Louisiana law required that railroads provide equal but separate accommodations for the whites and coloreds on their trains. Outraged, the black community of New Orleans decided to test this rule. On January the 7th, 1892, a gentleman by the name of Homer Plessy agreed to be arrested for refusing to move from a seat that was reserved for whites. He was a mixed race person. His ancestry was white and black. He boarded this all-white train between New Orleans and Covington, Louisiana. Because he looked white, they never questioned it. The conductor of the train collected all of their tickets at their seats. When they got to Plessy, he told them, "I am 7/8 white and 1/8 black." Once he had informed the conductor informed him that he would have to move to the all-colored section. He explained to them that he resented having to go and sit in the all-colored section since he was not all-colored. As soon as he refused and the train stopped at its next stop, he was immediately arrested. The Supreme Court decision in this case formalized the legal principle of separate but equal. This ruling required the railroad companies, if they had passengers on their train, to guarantee that their accommodations would be the same for both the white and the colored races. Accommodations provided on each railroad car were required to be the same that was provided for the other races. Separate railroad cars could be permitted. The railroad could not refuse you service unless you were in the wrong rail cars. Anyone who refused to comply was automatically arrested. The courts decided that this type of treatment did not infringe upon the 13th or 14th Amendment rights. The separate but equal document applied in theory to all public facilities, not only railroad cars, but schools, medical facilities, theaters, restaurants, restrooms, and drinking fountains. However, neither state nor Congress put separate but equal into their statutes. So there was no provision under the law to prosecute anyone for not giving you separate accommodations that were equal to the accommodations of others. Very much separate, but in no way equal. The myth was that the races were separated, but were provided equal facilities. Definitely a myth. No one believed it, almost without exception. Black students were given inferior buildings and instructional materials. Black educators were generally paid less than their white counterparts and had more students in their classrooms. Most African American schools had less public funding per student than their nearby white schools. They had the textbooks that had been discarded by the white schools and used equipment and poorly paid, unprepared, and seldom taught and well-trained teachers. Point of interest, I was a child of the Rosenwell School. I started there in first grade. When we received a book, books at that time had lines in the front for your name. So when you were signed a book, you signed your name at the top to say that that was your book. I never received a book that didn't have at least 10 names in it, which tells me that that book had been through 10 years. I went away to college before I found out that a school book should have had the current president in it, because I never knew who the president was. We didn't have television, okay? Right. So you have to consider the fact that we had to overcome a lot of separate but equal. Yeah. Very much separate, but in no way equal. because new research showed that segregating students by race was harmful to them and even the facilities that they pretended were equal. They were separate, but definitely not equal. They were found to be unconstitutional in a series of Supreme Court decisions under Chief Justice Earl Warren. Notice the name Warren has appeared. He was the first Chief Justice ever to take the side of people needing civil rights and their rights being protected. In fact, they started to name that era the Justice Warren era because he overturned over 60 years of cases that had been ruled as constitutional when in fact they were unconstitutional. Starting with the Brown versus the Board of Education in 1954. I was 3 years old. 3 years old when Brown versus the Board of Education. And that went nowhere as well until it made it all the way to the Supreme Court. However, the segregationists and overturning of segregational laws and practices was a long process that lasted through much of the 1950s, the 1960s, and the 1970s. I graduated in 1969. I started with separate but equal. I ended with separate but equal. In addition to other firsts, I was the first class my junior year to go through what they called at that time freedom of choice. Both schools existed. The black school existed, and so did the white school. But you were given a choice. You could decide which school you wanted to go to. Again, separate but equal did not work because I didn't see a single solitary white person that decided they wanted to come and go to school at Fairview. There were at least 10 of us that chose to go to LK, and I did in fact graduate from LK, but I was one of the first 10 black people to attend LK High School. We conclude, said the Supreme Court, that in the field of public education, that separate but equal has no place here. Separate educational facilities are inherently unequal. Therefore, we hold that the plaintiffs and others similarly situated for those things and those actions have been brought or by reason of segregation complied to and deprived of the equal protection of the laws guaranteed by the 14th Amendment. The underlying case began in 1951, just like me, when the public school system in Topeka, Kansas, refused to enroll a local black resident, Oliver Brown's daughter, at the elementary school closest to her home. Instead, they required her to ride a bus to a segregated black school much further away. The Browns and 12 other local black families in a similar situation filed a class action lawsuit in the United States Federal Court, alleging that the segregational policies was unconstitutional. A special 3-judge court of the U.S. District for the District of Kansas rendered a verdict against the Browns, relying on the precedents that had been set with the Plessy versus Ferguson. You remember the white guy that wasn't white at all? And its separate but equal doctrine. Brown's request went unheeded until the NAACP Chief Counsel, Thurgood Marshall, then appealed that Supreme Court ruling. In May 1954, the Supreme Court issued a unanimous 9-0 decision in favor of the Browns. The court ruled that separate educational facilities inherently are unequal, and therefore laws that impose them violated the 14th Amendment, equal protection under the law clause. I'm willing to take any questions that anyone might have or things that came up that you had not heard of before and are interested in additional information.
The first year going to the fight school here,
Mhm.
did you have other sisters and brothers that were still going to Fairview?
No, I am the end of the. No, I take that back. Cynthia, but Cynthia is 4 years behind me, so she
Okay.
would not have already gone into that.
Oh, okay.
Yeah, she's 4 years behind me.
What was it like going to an integrated school, and that was such a few of you?
I was very fortunate. I have to tell you, I was very, very fortunate because I had lived in California for 2 years and did not live under separate but equal in California. So I was indoctrinated to already be able to assimilate, okay? So I had a much easier time than some of the other people who were my age. Unfortunate for the people of Linden, I had lived in California before, okay? I came here with a different mindset. I entered a beauty contest that had never been entered by a black person before, and became a runner-up in that event. And the black community really rallied around me because they helped me pay for the float, my clothes, and just everything. Okay, so that turned out to be a good thing. And then I made the mistake of winning the Betty Crocker Award, the Crisco Award, and several other scholarship awards while attending LK. Everyone else got their rewards in an award ceremony on stage. I was given mine in the principal's office 2 days before. When I was in the beauty contest, they published everybody else's pictures in the newspaper. Mine was conveniently not printed in that paper. When I left this town at age 18, my name had been so prevalent that when I shipped my clothes and things by U.S. mail to Los Angeles, the man at the post office said, "So you're Sharon Pruitt." So I think they were kind of glad to see me go. But unfortunately, I'm back again. But it was an adjustment, but I must say it was a smaller adjustment for me than some of the other 9 that went with me when we went. Other questions?
But what made you choose that? Was it your decision or your parents?
To do freedom of choice?
Yes.
I came back from California, and there are people in this room who will understand this statement. We as a group tend to want to not help the other one up. I tried to enroll at Fairview High School. I rode the bus to Fairview, I got off the bus in Fairview, and when I got there, they informed me that my paperwork from California said that I was a senior already and that they could not accept me. My paperwork said I was a junior because I was a junior. And because they gave me static, I got back on the bus and rode to LK. Enrolled in LK in less than 30 minutes and continued to stay there for the next 2 years.
Oh, okay.
So it was one of those things. So no, my parents did not get involved in that. That was something that happened with Fairview. That happened at Fairview High School. Yeah. That would be Fairview. Oh, you were asking about experiences being freedom of choice? I was fortunate enough to have public speaking in my background, and I tried out for one of the roles in the senior play. And that's a big deal here. The senior play, the last thing of the year, blah, blah, blah. And we at that time had 2 students that did everything. If one was the queen, the other one was the princess. I mean, they did everything as a group. Brucey Glenn. And if you lived here any number of times, you know those last names. Well, I went to school with and graduated with the Brucey and the Glenn daughters. When they tried out for the play, first lead was going to go to one of them, second lead was going to go to the other. Unfortunate for them, I tried out for it, and I do believe, I can't prove it, I do believe that one of the 4 teachers that were voting for who was gonna get the role did not want to have it said that nobody voted for me. Unfortunate, they all voted for me as the one person. And I ended up with the second female lead of the senior play. I think it was an error, but there was nothing that they could do about it because the error had been committed already. And I was threatened throughout the whole process. I was left notes. The central piece was about a typewriter. So there were messages typed on the typewriter that I would have to see for that. So it was challenging, but it was worth every step of the way because I matured and I understood what was going on. So yeah, but it was a good, I don't regret any experiences that I had, none. Because I think it has enriched my life and my view, my worldview.
Mr. Haynes?
I'll hold it for you. Microphone. Oh, did you do?
I do not need the microphone. Good evening. This has been beautiful.
Amen.